Hello and happy weekend, everybody. I hope you're having a good one so far. For Monday, we're working on how the Supreme Court hears cases. So what goes into their decision making in picking a case? How does a case get to the Supreme Court since it's the last court? So that's what we're concentrating on today. Something key to remember is that the Supreme Court has both original and appellate jurisdiction. Okay, remember original jurisdiction, that's just where they hear the case first. There's less than 5% of the cases the Supreme Court hears that they use original jurisdiction. The other type is appellate, or the appeals, and this is where it's going to start off in another court and work its way up to the Supreme Court. 95% of the cases the Supreme Court hears are based on appeals. So these cases have already been heard at state level or the federal level, and they've gone to a court of appeals and they work their way up. So that's what we're looking at. All right. So first off, two things happen. First off, the Supreme Court, during their work week, they have to decide which cases they're going to hear. And then they also have to make decisions on the cases that they've chosen. Remember, the Supreme Court gets to pick the cases they hear. So when it's appealed to the Supreme Court, they get the brief, and they will spend time looking at it. We'll talk about the process in just a moment. And they'll decide, hey, we want to hear this case, or no, we don't. So part of their work week is deciding, yes, this is a case worthy of the Supreme Court. And then the other part of their work week might be listening to the oral arguments and then meeting and discussing the case to make a decision on it. So the two processes. Let's go through getting on the docket first. All right. So the cert pool, if you look down the bottom of the left side, it says writ of certoria. That is what the cert pool is. Okay. That is just the pool of cases that they have to pick from. So there's thousands of cases that gets appealed to the Supreme Court. And so they have to wade through that pool. So that's what the cert pool is. Okay. The role of the Solicitor General, remember, this is a position in the United States government. It's picked by the president, and then they are the ones that are going to help make decisions on trying cases and things like that. They're going to work closely with the Supreme Court. Okay. They'll give them opinions on cases. They might recommend a case goes to the Supreme Court and things like that. Alrighty. So once it gets into this pool, so that, hey, it's been appealed to the Supreme Court, what happens to it then? Well, the Supreme Court will get the case, and they will have a meeting each week where they get the cases and they can go through them. All right. So here's a report of 50 cases. The 9 justices go through them. They will meet and they will discuss the list and talk about which cases they feel are important for them to hear, which cases should be kicked out. And they'll decide to if they want to hear the case or not. If 4 of the justices decide they want to hear the case, then it goes to the Supreme Court. Okay, so it only takes 4. This way, it's not a majority thing. This way, the minority always has a voice. If they decide to hear it, it is granted the writ of certoria. I always say it wrong. It's a Latin word. It's a dead language. I don't speak it, but it's that word, the writ of certoria, or however you say it. All that means is that the court has called up the case and is going to hear it. Now that it's on the docket, some things happen. First off, people that are interested in the case might write an amicus curiae brief. Once again, a Latin word. I don't say it correctly, probably. All this is a letter to the court. So if this is an environmental issue, maybe the World Wildlife Fund writes a letter to the Supreme Court saying, hey, we really don't like this case. We think you should rule this way. Or here's some facts of the case. It's a gun control issue. The NRA writes one saying, we really think you should rule this way. If you remember back to August, we talked about McDonald versus Chicago and DC versus Heller. The NRA was writing letters to the Supreme Court in the form of amicus curiae briefs. They don't play any really role. They don't factor into the decision making of the courts, but it's a piece of information that the courts get. They will listen to oral arguments. You get 30 minutes. So you as the defendant or plaintiff get 30 minutes, and then the other side gets 30 minutes. And that is it. There's no testimony. There's no, let's call this witness. It is just oral arguments. And then they will also look at their case records. So what's happened in the lower courts. They will have a conference and discuss the cases, and then they make a decision, and then they write up their opinion. Okay. So the actual decision making can move pretty quickly since it's only 1 hour that they have in court where they're listening to oral arguments. Conditions for bringing a case up. You've got the lower court decision conflicts with precedent. We're going to talk about what precedent is in just a moment, but that's the case that's already been ruled on. Inconsistencies between courts of different states. So Florida rules one thing and Georgia rules another. Split decision in Court of Appeals. So if it's a 2-to-1 decision, they sit in groups of 3, remember, on the Court of Appeals. So if it's a 2-to-1 decision, there's a good chance they'll bring that up. And then the Court of Appeals decision that conflicts with another Court of Appeals. So if there's 2 similar cases and the Ninth Circuit rules one thing and the Sixth Circuit rules another, then that's probably going to get brought up. Now, in class on Monday, we're going to look at some other reasons and that you're going to work with. But these are some of the main reasons the Supreme Court may grant certiorari to a case. The opinions. You've got 3. You've got the majority opinion, concurrent opinion, and the dissenting opinion. The majority opinion is the the winning side. The Chief Justice will choose someone to write the majority opinion, and this kind of becomes the rule of law on a decision. All right. So the majority opinion, whether it's 5-4 or 9-0, the Chief Justice will choose someone from the majority to write the opinion, and this is what's going to be used in law books and those sorts of things. Concurrent opinion, those are also on the winning side, and they will write their opinion, but maybe they saw it differently. Maybe they voted for this because of a different constitutional issue. So they're going to get their opinions out there in the concurrent. Hey, yes, we agreed this was the right decision, but I didn't agree with the majority opinion. I thought it was a different issue that got this case decided. And then the dissenting opinion is going to be the losing side. Okay, so these are if it's 5-4, then all 4 are going to write it. If it's 8-1, maybe that one person writes it. Okay, so why do we write opinions? Well, the majority, once again, that's going to be how this case affects the rest of the country. That is how this case is going to be enforced around the country. This is what we saw. This is the constitutional issue we fixed, or whatever it might be. Okay, concurrent opinions, you want to get your stuff out there. So if you had an opinion that was similar, but you just saw it differently, you want to have that out there. And the dissenting opinion, if things go wrong, you want to be able to point back and say, I told you so. Not really, but you do want to have your opinion on record that I didn't agree with this. Okay. Factors that determine outcomes. 2 main things I want you to get here: precedent and stare decisis. All right. Now they seem kind of the same, so just keep that in mind. Stare decisis is where you look to the past to guide decisions. So the Supreme Court looks at old cases to help guide their decisions. All right. Precedent is a case that has become a legal authority, basically. Okay. It's old decisions, but they are kind of set in stone. All right. Stare decisis is just the process of looking at some of those precedent-setting cases. Hopefully that makes sense to you. Okay. Now, the Supreme Court can overturn precedent-setting cases, and there are any number of precedent-setting cases. Roe versus Wade, we've talked about. The Brown versus Board of Education. Now, remember that overturned Plessy versus Ferguson, which was another precedent-setting case. So the Supreme Court can overturn their own precedents. Block voting, that's just the majority minority. So right now it's 5-4. Okay. Swing vote, who's going to be that 9th vote that could possibly make the decision because they don't want to have a tie. And then recusal is when they remove themselves from a case. Maybe they're too close to it or something along those lines. Judicial implementation, what happens? So the interpretation population, that's the judges. So they're the ones looking at the cases and making an interpretation of it. The implementation population, those are the ones who enact the decision. So the bureaucratic agents who have to go out and implement the decision. And then the consumer population, those that are affected by the decision. That's me and you. Okay. TLO versus New Jersey, where the little girl was searched. You as students are the consumer population because you're affected by that. You're allowed to, the administrators are allowed to search and seize your stuff. Original versus judicial discretion. Original intent is a belief that the justices should use the framers' interpretation of the Constitution. So when they look at a court case, They should try and get into the heads of the framers in the original Constitution and what they believed. You see some terms there: strict constructivist, judicial restraint. They are not trying to set policy. Judicial discretion uses judicial activism, and this is where the judges they can go off the rails a little bit with the Constitution. They're setting policy in this role. Okay, so original intent, you're very much so. This is what the Constitution says. This is all we can do. Judicial discretion, activism, it allows for some interpretation of the Constitution. Factors that limit judicial activism: the President and Senate determine who's on the Supreme Court. The President picks them, the Senate confirms them, so they get to make those decisions, so they'll have an idea. Congress can always amend the Constitution, so if a court case comes out and the Congress does not agree with it, they can always make changes. Remember, an amendment does not get looked at by the Supreme Court. Passes clarifying legislation to overcome statutory construction, so they can always pass legislation to get around that. Okay. Lastly, how the court set limits on what it hears. They do not hear political questions. So, like I said in the last one, the Congress and the President cannot agree on a budget. It's not going to go to the Supreme Court. They're not going to make those decisions. Okay, that's it for today. Don't forget, we're going to answer another 5 questions on Monday morning first thing, and then we'll get going with our stuff. All right. Once again, I hope everybody had a good weekend, and I'll see you on Monday.